Welcome to SelfHelp's Introduction to Conservatorship. Today's workshop is being presented to you by the Riverside Superior Court's SelfHelp Legal Services. We are staffed by attorneys and paralegals whom provide free legal information and assistance only to self-represented litigants in certain types of cases. Our scope of services cover 3 general areas that include probate, family law, and civil. Scope of services. What can SelfHelp do for you? Our team is here to teach self-represented litigants how to navigate their cases through the court system. We can provide legal information. We can explain the court process. We can teach you how to complete your forms, but you will always be responsible for completion and accuracy. We can also provide you information on other legal resources that are available. What can we not do for you? We cannot assist you if you have an attorney or end up hiring an attorney. We will not represent you in your case. We do not establish an attorney-client privilege as we are allowed to provide assistance to both sides of the case. We do not provide legal advice or strategy. We do not proofread or write declarations. We do not fill out court forms for you. We also do not provide assistance in the discovery process. The more complex your case is, the less likely it is something SelfHelp can assist you in. However, our team will do our best to provide you with other legal resources available. Today, we will first explain what a conservatorship is. We will also describe alternative options and different types of conservatorships. Then we will explain how you can access SelfHelp for further assistance. What is a conservatorship? A conservatorship is a court proceeding where a judge can appoint an adult person, called the conservator, to be the one in charge of providing physical care and making decisions for another adult person, who will be called the conservatee. It will have to be proven through the proceedings that this person cannot otherwise provide for their own physical care and make sound decisions due to a physical impairment and/or disability. Note: the court may grant a conservatorship if it is the least restrictive option to help a person who has a sudden lack of function, impairment, and/or disability to lead a life of their choice. This must be proven during the course of the initial proceedings. This requirement must also be continuously satisfied throughout the course of the conservatorship. Therefore, biannual investigations are conducted. Remember, the least restrictive option means there are no other alternatives available or appropriate. Alternative options. We will now explain some alternative options for you to consider, as the court expects that if you pursue a conservatorship, It would be because less restrictive options would not work for your particular situation. Supported decision-making. Supported decision-making is a process that allows a person with disabilities or impairments to receive support from trusted people in their lives, but maintains the ability to make their own decisions. The person with a disability chooses the people who support them, including family, friends, or professionals. The supporters agree to help the person with a disability understand, consider, and communicate decisions. Supporters also give the person the ability to make their own informed decisions. Supported decision-making does not involve the courts. Power of attorney. A power of attorney, known as a POA, is a document that grants specific powers to someone you trust, called an agent or attorney in fact, to act on your behalf. There are different types of POAs that can manage your financial or legal decisions, healthcare decisions, or it can be limited such that the powers only apply for a particular decision and don't carry over to other parts of the person's life. The person who is granting power of attorney must have their signature notarized on the document to be valid, but a POA is not filed with court or signed off on by a judge. Note, not everyone accepts or honors a power of attorney. Advanced Healthcare Directive. An advanced healthcare directive allows a person to name another individual to make healthcare decisions on their behalf. The document would contain instructions that document a person's desires regarding healthcare, allowing them to be followed if the person is unable to communicate or make decisions at a later time. It can also determine ahead of time what type of medical treatment they would want if they are unable to express their preferences in the future. Advanced healthcare directives are not filed with court or signed off on by a judge. Representative payee. A representative payee is an individual or organization appointed by Social Security to manage a person's Social Security or supplemental security income. They must use the money in the best interest of the person, often called a beneficiary. They will receive the public benefits, ensure that all bills are paid, and provide the beneficiary with money for their personal needs. For more information on the representative payee, you can visit the Social Security Administration's website at www.ssa.gov/payee or the Disability Rights of California's website at www.disabilityrightsca.org. Special Needs Trust, or a CalAble account. A special needs trust is a way for a person with a disability to maintain eligibility for public benefits, such as supplemental security income and Medi-Cal, even while having assets that would normally make them ineligible. For more information, contact the Department of Healthcare Services at 916-650-0490. A CalAble account is for a person with a disability that started before age 26 and who also receives either SSI or SSDI can open a CalAble account. An eligible person can save up to $100,000 in a CalAble account without affecting their eligibility for their other benefits. For more information, contact CalAble at 1-833-225-2253. Guardian ad litem. A guardian ad litem may be appointed in any case when it is deemed by the court to appoint a guardian ad litem to represent a person who lacks legal capacity to make decisions. A guardian ad litem stands in the place of a person with a disability in a court case. The guardian ad litem is able to hire a lawyer and make decisions in a lawsuit for a plaintiff, defendant, petitioner, respondent, or other party who is unable to understand or make a decision in the case. Types of conservatorships. If after attempting the alternative forms of assistance, you decide that a conservatorship is still the least restrictive option, then there are also different types of conservatorships to consider, as the person you are trying to assist may need different levels and different types of help. A general conservatorship is for adults who are unable to provide for their personal needs due to physical injury, dementia, or other reasons rendering them incapable of caring for themselves or making them subject to undue influence. In a conservatorship of the person, the conservator is responsible for making sure that the conservatee has proper food, clothing, shelter, and health care. Depending on the conservatee's ability to understand and make decisions, the conservator might also need to make important medical choices for the conservatee. In a conservatorship of the estate, the conservator handles the conservatee's financial matters. These duties include, but are not limited to, protecting income and property, paying bills, and preparing and filing taxes on behalf of the conservatee. With that said, the conservator is also required to prepare and provide regular financial reports to the courts and all interested parties to ensure the conservatee's finances are not being abused. A conservatorship may be requested solely over the person, or solely over the person's estate, or over both the person and the estate. It will be at the discretion of the court to determine whether either is necessary. Limited conservatorship. If you are pursuing a limited conservatorship for a person who is developmentally disabled, the powers of the conservator are limited so that the disabled person may live as independently as possible. The conservator's powers will be limited to certain specific powers according to what powers the conservator requests and what the court will approve. Some powers may include giving or withholding medical consent or making decisions about their education. In addition, just like the general conservatorship, a conservator may ask to be appointed conservator over the person, over the estate, or over both, based on the needs of the conservatee. Duties for conservator of the estate include, but are not limited to, posting bond. On the day of your appointment hearing, the court may order the conservator to post bond. This is similar to obtaining an insurance policy to protect the conservatee's estate from misconduct or neglect. The amount is set by the court based on a specified percent of the value of the estate. Recording letters. If the conservatee owns real property, you are required to record a copy of the letters issued by the court with the county recorder's office within 90 days of appointment. Inventory and appraisal. Also, within 90 days from your appointment, you will need to prepare and file an inventory and appraisal, which is a list of all real and personal property of the estate. It is a snapshot of the conservatee's assets on the date the conservator was appointed. Once you have prepared your inventory and appraisal, you are to send it to the appointed probate referee, who will complete the forms with the values for all non-cash assets and return it back to you for filing with the court. You are also required to have the final inventory and appraisal served on all parties. Accounting. The first accounting is due 1 year after the date you are appointed. Subsequent accountings are due every 2 years or more, as ordered by the judge. It is important for you to maintain good records, as the court may audit your account. LPS Conservatorship, which stands for Lanterman Petrus Short. This is a mental health conservatorship for a gravely disabled person who may be a danger to themselves or others and requires hospitalization in a psychiatric facility. The most common mental illnesses that can be eligible for LPS conservatorships are schizophrenia, bipolar disorder, manic depression, schizoaffective disorder, clinical depression, and obsessive-compulsive disorder. Only the public guardian can establish an LPS conservatorship, and there are many extra protections to ensure that the conservatee's civil rights are not being violated. Note: SelfHelp does not assist with LPS conservatorships. However, you can request for an informational guide by emailing us at workshop@riverside.courts.ca.gov. There is also an alternative to the LPS conservatorship for you to consider. This involves petitioning for your loved one to participate in the CARE Act. This is a new legislation recently enacted in the state of California for persons with schizophrenia or other psychotic disorders. This program provides a less restrictive alternative to state hospitalizations or an involuntary conservatorship. The CARE Act creates a voluntary agreement that the respondent participate in behavioral health services. The agreement can include court-ordered treatment, support, and a housing plan. For more information, you may visit our website at www.riverside.courts.ca.gov/divisions/care-act. You may also contact the CARES line at 1-800-499-3008, or you can contact SelfHelp at 951-274-4499. And now we will discuss some frequently asked questions. My disabled adult child needs more hands-on assistance. Don't I need a general conservatorship to have more powers? No, a general conservatorship does not give you more powers over the conservatee. It will be very general in nature, which will cause you issues when you try to make specific decisions for a developmentally disabled adult. For example, a general conservatorship will not allow you to make decisions regarding their education, or stop them from entering into a marriage, or stop them from entering into a contract. A limited conservatorship does not mean it gives you less powers than a general. It is just more specific in nature. I need to manage the conservatee's public benefits. Don't I need estate powers? No, you do not need a conservatorship of the estate if the developmentally disabled adult you care for gets public assistance, like supplemental security income or Social Security, but has no other assets, or if the developmentally disabled adult earns a wage. But you do need a conservatorship of the estate if the developmentally disabled adult has other assets, like an inheritance or settlement from a lawsuit that is not in a special needs trust or in a blocked account. Can I also ask for an emergency or temporary conservatorship? A temporary conservatorship is not required, nor is it automatically granted just because you ask for it. You can ask for a temporary conservatorship depending on the circumstances. The judge will grant these in extreme situations where you need immediate decision-making powers that could not wait for the official court hearing. If orders are made in a temporary conservatorship, it will end when the binding general, LPS, or limited conservatorship begins. Why can't I just do a general or a limited conservatorship for my mentally ill family member? A general or a limited conservatorship proceeding will not give you the legal authority to make decisions for a seriously mentally ill person. Only in an LPS conservatorship can the appointed conservator, which will be the public guardian, be given authority over the mentally ill adult, which includes, but is not limited to, getting the person individualized treatment, supervision, and placement. Accessing self-help. Our self-help legal services are available through the following methods. You can contact us through our phone lines for brief questions or to request for a telephone appointment. Our phone lines are available Monday, Wednesday, and Thursday from 8 a.m. to 12 p.m. at 951-274-4499 or 760-393-2163. You may also email us at workshop@riverside.courts.ca.gov to request for an appointment. Note: our response times will vary. Due to a high volume of litigants contacting us, it could take from a week to 2 weeks to be able to offer you an appointment and/or respond to email inquiries. We also offer in-person probate clinics for brief questions or forms review at designated centers. Please check our events calendar at www.riverside.courts.ca.gov/self-help events.